Looks like Diddy won't be home for the holidays, y'all. Let's talk about it. Welcome, timekeepers. For those that are new here, thanks for stopping by the My Reader Minutes. To all my new subscribers, thank you for joining me on my journey. Today, I want to talk about Diddy's last bail hearing ruling. Okay, the judge came down today and ruled that he ain't coming home. He ain't coming home. I did pull the ruling. We can go over it. I looked over it, the beginning parts of it. It's a lot of legal mumbo jumbo. I want to state for the facts, I am not a lawyer, nor am I a paralegal, nor am I in the legal realm at all. However, I can read, so that makes me qualified to read the document. No, but I wanted to go over with you all. Let's talk about it. Leave your thoughts and whatever you think in the comments. But let's pull this up really quickly. It's not that long. It's like 4 pages. Well, it's actually 1, 2, 3. Yes, 4 pages. 5 if you include the signature page, but I'm not going to read all of it. Actually, I might. I don't know. Depends. He has a part in there redacted, it looks like, but it's not a big piece that's redacted. Okay, let me see. Okay, here we go. So this was filed today. And basically his ruling is no condition or combination of conditions will reasonably assure that the safety of the community. And this paragraph, when I just read it earlier, looks like he gives us the reason for his ruling. I think he combines like all of the complaints, the evidence, for all 3 of the bail hearings together to make his ruling, and he tells us like what he used to come up with his decision. So basically he says the court has evaluated each of the factors that it must consider under 18 USC 3142, blah, blah, blah. It says nature and circumstances of the offense charged, weight of the evidence against the person, history and characteristics of a person, and nature and serious of the danger that would be posed by the person's release. So he took all of those factors in consideration. It says courts have a broad discretion in weighing the factors. So the court has also reviewed the information submitted by Combs and the government across all 3 bail hearings in the case. So he used everything to come up with his ruling, right? And he says, see dockets 1, 5, 8, 9, 12, and all the way through to 91. Okay. He said the court finds that the government has shown by clear and convincing evidence that no condition or combination of conditions will reasonably assure the safety of the community. In support of these findings, the court provides the following reasons. So he lets us know, he breaks it down as to why he's saying, no, he got to go back to lockup. So it says, even if Combs successfully rebutes this presumption, which the court assumes he will, it remains one of the factors that the court considers a determination whether the government has met its burden of persuasion. And he feels like, based on the evidence, that the government met theirs, but the defense didn't meet theirs. So it says whether or not The information submitted by Combs and his renewed motion meets the statutory standards for reopening a detention hearing. The court exercises its inherent authority to review the entire record to determine whether the government has met its burden of proving the pretrial detention is required. So it says the indictment charges Combs with serious and violent crimes. It alleges that for decades, Combs abused, threatened, coerced women and others around him to fulfill his sexual desires, protect his reputation, and conceal his conduct. To do so, Combs relied on employees, resources, influence of the multifaceted business empire that he led and controlled, creating a criminal enterprise whose members and associates attempted to engage in, among other crimes, trafficking, forced labor, kidnapping, arson, bribery, and obstruction of justice. What was the forced labor? Oh, okay. Somebody let me know. What did they consider the forced labor? Is that the prostitute? I mean, I don't know. It says that Combs himself carried a brandish firearm to intimidate and threaten others, including victims of and witnesses to his abuse, and notes that during searches of his residence in March, law enforcement seized firearms and ammunition, including 3 AR-15s with defaced serial numbers, as well as a drum magazine. Now, I thought it was just one. It was 3? Did that come out before? That's new to me. I glanced over this, but 3. Okay. I thought it was only 1. Anyway, 1 was too many, but 3, okay. When Combs, when Combs' authority and reputation was threatened, the indictment alleges he and members of his enterprise engaged in acts of violence, threats of financial and reputational harm, and verbal abuse. These acts of violence, including kidnapping and arson. Kidnapping and arson. Well, okay. The indictment also charges Combs with trafficking in violation of 18 U.S.C. blah, 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 that legal code right there, requiring the court to consider the nature and circumstances of the offense charged, including whether the offense is a crime of violence, whether it's a violation of Section 1591, and whether it involves a controlled substance or firearm. The government has presented direct evidence of Combs' violence. This includes video footage from 2016. We know the Cassie video. Yes, that showed that he is not a nice person. And then they also submitted text messages between Combs and victim 1. Victim 1, I guess, is Cassie. We've acknowledged that, right? And then they have text messages from the hours and days following the 2016 Intercontinental Hotel incident. She says, I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done. I still have crazy bruising. And then they redacted this part, so I don't know what else he did to her. That's crazy. Nevertheless, Combs argues that the weight of the evidence does not support a charge of trafficking. In his view, it supports a toxic, sometimes violent, long-term relationship between Combs and victim 1. But regardless of whether that's true, there's a compelling evidence of Combs' propensity for violence, requiring the court to consider the history and characteristics of a person. So, regardless of you saying that was your girlfriend or not, and that it was all consensual, we saw how you get down, and that ain't cool. So, if you do that to your girlfriend, imagine what you do to someone that really don't really mean nothing to you. Just saying. There is evidence supporting a serious risk of witness tampering. For example, Combs initiated and had unexplained communications with witness 1. What's that? Who was subpoenaed to testify before the grand jury in June 2024, and in fact, testified on July 25th, 2024, according to docket 69 at 10. Combs was represented by counsel during this time, and they have offered an explanation for some of the communications, but they could not explain them all. For instance, Combs' efforts to call and text witness one even after his grand jury testimony or Combs' deleted texts with his witness. Although the phone records confirm that the defendant using a particular phone number and witness one exchanged multiple text messages from June 2024 through August 2024, and there were no such messages recovered from Combs' cell phone associated with that number. Further, Combs' interactions with witness one are directly in conflict with defense counsel representation to Judge Carter on September 18th that Combs did not reach out to the grand jury witness. He didn't do it, and he wouldn't do it. So he's saying that they have evidence that he did exchange text messages between June 2024 through August of 2024 with witness one. And I guess they got that from witness one's phone. When they looked at Diddy's phone, wasn't no messages on there. His counsel also, before Judge Carter, said he didn't do it. So they perjured themselves? That can't be good. There is evidence that Combs violated Bureau of Prisons regulations during his pre-trial detention to obscure his communications with third parties. He paid other inmates to use their phone access code numbers to make calls to those not on his approved contact list. Well, we know he did that. We know that that happens in the jails because they only have a certain amount of limits. They're only limited to a certain amount of minutes. And if they run out, they barter. He got money, so he can pay. But they barter, or they pay if they can, to use other people's phones. Not so much to call people not on the approved list, but just to make phone calls. Because everybody wants to make a phone call. Everybody calling home. But in his case, he was calling people that weren't approved. So that's another strike, right? Instructed family members and defense counsel to add. Oh, wait a minute. He instructed family members and defense counsel to add other people to three-way calls. So the defense counsel was helping him add people onto calls. The hell? Send them to jail. Contempt of court. Oh my God, this is crazy. So that their communications were more difficult to trace and used as a messaging program called Contact Me ASAP. Although the court recognizes the parties dispute whether Contact Me ASAP is permitted or not, the government gives examples of Combs' communications utilizing these means from as recently as November 4th, 2024, directed to efforts to influence the jury pool, according to docket 69 at 19 and 21. So he's even referencing in the docket where the government has spelled out where he has violated just the house rules with the phone. Oh, God. Or to reach out to potential witnesses. The court makes no determination that the content of Combs' communications through these channels were improper. However, his willingness to skirt BOP rules in a way that would make it more difficult for his communication to be monitored is strong evidence that the court cannot reasonably assure as to the sufficiency of any conditions of release, especially given that they occurred when Combs was seeking bail and when he knew the government's concerns about witness tampering and obstruction were front and center. So you don't even care that this was their main contention with you, because you're Diddy, you're Sean P. Diddy Combs, and you can do what you want to do when you want to do it. I don't care if I'm violating house rules. I'm not breaking no laws, and I know my man, he owe me because I didn't pay him unts amount of dollars. I'm gonna get me another phone call, and even after you left court, you still using the stuff that they know that they brought up for the judge. Just to here, and you went back and did the same thing. Like, that's just dumb. That's just really dumb. And he has no respect for the law, for authority, for anybody. I'm being accused of violating and tampering with it, but I go right back to doing what I've been doing. Okay. Yeah, okay. Where would I leave off? Okay. C docket describing. Okay, so C docket 17 at 9, describing Combs as a serial obstructor. Docket 19 at 2, citing obstruction as a primary reason for seeking detention. So they're citing everything as to why that he needs to stay locked up because of all these violations with the phone and tampering, witness tampering. Yet you go back and do the same exact thing right after court. You probably say, oh, I got to get back because I got to make a phone call. Underscoring the court's concern, despite defense counsel's assurances to the court at the November 22nd, 2024 hearing with Combs in attendance that Combs stopped using Contact Me ASAP as of November 16th. Underscoring the court's concern, despite defense counsel's assurances to the court at the November 22nd, 2024 hearing with Combs in attendance that Combs stopped using Contact Me ASAP as of November 16th, 2024. Okay, so his counsel said that he stopped using that app, as of the 16th. And they assured, I guess, he wasn't going to use it anymore, right? That was 11:22 okay, so this is at 37. The government indicates that Combs has continued to use this service as recently as this past Sunday, November the 24th. Are you kidding me? Wait a minute. Everything relies on you being able to follow the rules. If you can't follow the rules in a restricted area facility, why would anybody in their right mind release you to a less restricted area? You running amok in jail. You want to go to your apartment? This was as of this past Sunday, 3 days ago. Even though you're defense counsel, you got the defense counsel looking dumb. Because they keep coming out here saying, you're not doing this, you're not doing that, you're not doing this. Knowing all along that you're doing whatever you feel like you're big and bad enough to do. And they may be helping you, clearly, because they up there clicking people on the three-way calls themselves. Because so they can't trace the call. So if you're using somebody else's phone and they call your lawyer, hey, I need you to call so-and-so. They can't trace that call, but they can hear it. Oh my God. All right. The court further notes that it held an emergency hearing on November 19, 2024, to address the government's uses of notes on legal pads recovered from Combs' bunk during a sweep of the Metropolitan Detention Center. Okay. At that hearing, defense counsel advised all these legal pads say legal. Yes, they are marked as legal. Docket 88 at 34. After the hearing, the court inquired why, in light of counsel's representation that the notes had issued were on the legal pads, they were clearly marked as legal. Photographs taken during the sweep show no such labels. Docket 77. At the November 22nd, 2024 hearing, defense counsel admitted that it has to be the case that as of the day of the search, legal wasn't written on every legal pad, and that they were not sure whether the pad presented to the court had legal on it at the time of the sweep. Okay, I don't understand that, but that sounds like a lie. The circumstances of this incident and the misrepresentation made at the November 19, 2024 hearing where Combs was present bear on whether the court can be reasonably assured that any condition it poses will be followed, or whether the inadvertent or active subversion they will be broken and that the community safety threatened. So the court assumes that it may consider the bail package that Combs has proposed, but see United States versus Bustani. We now expressly hold that the Bail Reform Act does not permit two-tier bail system in which defendants of lesser means are detained pending trial while wealthy defendants are released to self-fund private jails. However, given the nature of the allegations in this case and the information provided by the government, the court doubts the sufficiency of any conditions that place trust in Combs and individuals in his employ, like a private security detail, to follow those conditions. I agree with the judge. I agree with the government. You got your defense counsel up here trying to run amok, making them look like clowns, trying to defend your awful behavior. And they keep looking crazy. Luckily, you're paying them a pretty penny to look crazy because they just taking your money for real. But you got them making phone calls for you. And if you were to go home or go to a place of residence other than jail, I don't even know who he would get to. No, that ain't gonna work. That ain't gonna work. I agree. I agree. I'm sorry, y'all. I mean, I'm sure it's gonna be some haters in the comments, and that's fine. And you can disagree with me all day. I don't care. No. Nope. And we can talk about it. I ain't gonna be mean or disrespectful. We can talk about it. But the judge made the correct decision. No, he's not ready. He's not. He don't care. He don't. He's already let us know. Rules don't apply to him. See United States versus Arena propose at best elaborately replicate a detention facility without the confidence of security such as facility instills. Citation omitted. Okay, the court observes that pretrial services reached the same conclusion, noting that the November 22, 2024 hearing that the conditions are insufficient and that there are no conditions that could reasonably assure the safety of the community. Finally, the facts and the circumstances here differ from those in Combs' principal cited authorities. In United States versus Fox, 2022, the Second Circuit recognized the case presented as extremely close call, and that any losing of the conditions or more compelling evidence presented by the government could well tip the balance in favor of pretrial detention. But in Fox, the Second Circuit did not address a risk of obstruction, and the government failed to engage with the proposed bail restrictions. United States versus Jeffries, while the government raised danger, its principal concern with respect to defendant Michael Jeffries was flight. He had no criminal history. The alleged criminal conduct, which did not involve the kind of violence or RICO allegations made here. So they were okay. So this is when they were trying to say they let Jeffries out on a $10 million bail for similar crimes, as trafficking and the like. But he doesn't have a RICO. He doesn't have firearm charge. You don't have any of that. So they're saying that's the difference. Plus, the man is 80 some years old. So there's that. Okay, so abated nearly a decade ago. Jeffries was 80 years old. Yep. See letter in advance of arraignment. U.S. So they have a letter there. Okay, whatever. Combs' motion for temporary release is denied. Oh well, I had already said in my last video, you need to get comfy. Get comfortable where you're at, or maybe what they should have done was ask for him to be moved to another facility. If that facility is so bad And can't nobody stand there. Obviously, he's making a go of it. He's making it work. So it can't be but so bad. See, because he's not even willing to follow the rules so he can get out. Jesus. How hard was that for him not to pick up the phone over the weekend? Are you kidding me? The court also finds that Combs has not shown that a temporary release from detention, pursuant 18 USC, blah, 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 3142, is warranted. Under this provision, a judicial officer may permit the temporary release of the person in the custody of a U.S. States Marshal or other appropriate persons to the extent that the judicial officer determines such release to be necessary for preparation of the person's defense or for another compelling reason. Combs' application under 3142 is based on the conditions at the MDC, which he says makes trial preparations impossible. But giving Combs access to counsel and documents, there was an issue with Combs receiving a laptop for the purpose of reviewing discovery, but the court addressed that. The firm deadline for the government's discovery, the end of this year, and the time left before the trial, over 5 months. So Combs has not carried his burden of demonstrating that the release for detention is necessary for trial preparation purposes under the whatever this is, 3142, or the Constitution. But the court will promptly address any issues that arise with respect to Combs' trial preparation. If the circumstances materially change, he may renew his application under 3142. So the motion is denied. The clerk of court is respectfully directed to terminate docket 60. So ordered. That was today. So if by chance that they have multiple lockdowns and this affects his legal team, they will address probably moving him to another facility. I don't think he's ever going to go to an apartment. That would have been nice, I'm sure, but no, he couldn't even stay off the phone for a weekend, y'all. He couldn't stay off the phone for a weekend. He went back on the phone the 24th, which was Sunday. The judge said, I need you all to submit letters Monday because he wanted to review the case to get a better feel of what he was looking at. So he combined all of the bail hearings plus weighed in what the government proposed as far as what kind of communication he's supposed to have, what the defense submitted. He asked for 2 letters, right? He also asked for the pretrial people to weigh in. He got everybody's information. The government spelled out he did this, 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 with the help of other inmates and his legal team. Then the legal team says, oh, well, he's not going to use the Contact Me ASAP app no more. He's not going to use it. Matter of fact, he stopped using it as of November the 16th. He's not going to use it. And daggone it, did he get back on it on Sunday? Man, you don't want to come home. You don't want to come home. And you know what? You shouldn't. Because you cannot follow rules. That was the whole premise. Can we let you out? Are you going to follow rules? You let them, you showed them. You don't, and you don't care. Y'all, what do y'all think about this? I think the judge ruled the way he was supposed to rule. And I don't have any legal background, but I can read. And I know what it read now. I don't know what all those US what is it? USC, what is it? What are those things? I don't know all of the different legal codes. I don't know what they mean. I'm sure I can Google them and look them up. But it tries to spell it out for you, I think, on some of them. But, it is what it is. I can read. And I see why he was denied. Y'all tell me what y'all think. Leave your notes in the comments. Ooh. Diddy. Well, happy Thanksgiving, Diddy, and Merry Christmas and Happy New Year. Y'all, please like, share, and subscribe if you haven't already done so. Everyone be blessed. And to all of you out there, have a happy Thanksgiving. Be blessed. Peace.